chapter 11, right? It's not just the Arbitration Act, it's the Arbitration and Conciliation Act. Okay, so just starting out for this chapter, I need to first introduce you to a concept which is known as something known as ADR, Alternate Dispute Resolution. What is dispute resolution? Anything which you go to the judiciary for is dispute resolution. So they are saying alternate dispute resolution. So that means apart from the judiciary, you're going somewhere else to get some kind of a remedy. Okay, so this, why has this alternate ADR come up is because I may have mentioned to you earlier that in our judiciary itself, we have some basic problems. Okay, and those basic problems are, it is too time consuming. By the time you get past the procedures, the delays, etc., justice is delayed. So one is the process is extremely time consuming. The second thing is the number of judges are never enough, or the proportion of cases to judges ratio is very disproportionate. So you will see one judge technically would have to handle close to 20,000 cases per day to finish the actual caseload before the judiciary. And this fact is a slightly old fact. We know that there are more cases pending. So we don't have enough judges and we have a very high caseload. Then also one more thing is that apart from being time consuming, the number of judges being lesser, yeah, this is what I'll call as our basic problems over here. Okay, so what has happened over time is that they have tried to find different ways in which to streamline the process. There's something known as the Lok Adalat, circuit courts, weekend like Sunday court, etc., traveling courts, wherein the judge will travel to certain places, they'll take up matters and then eventually they'll get it heard over particular days. But it wasn't very effective. Okay, then now we have something known as the Lok Adalats. Those are also what we call as temporary courts or moving courts. Now we have a permanent Lok Adalat, but the object of what I'm trying to tell you is we have gone into alternate dispute resolution. But what they eventually realized was, for a lot of civil disputes, the common problem is miscommunication, such as divorce, property disputes, inheritance disputes, contracts. Things like this could have been solved simply over better communication. Take for example divorce proceedings. Okay, till the very end they'll take the divorce proceedings and in the last minute they'll say, I don't want a divorce. Or even for contract, like I don't pay you money, you will file a suit against me, just to later realize that we can settle it out of court. If you had just simply got the two parties together in one room and just asked them to communicate, you will realize that close to 40% of their problems is solved. Okay, and so they took that benefit. They said, the court started saying, go try solving this problem on your own, or maybe not on your own, because they would have tried solving it on their own only and they would have come to the court of law. But if it is a matter that can be referred and settled outside, then why don't you try and settle it outside? Especially when I'm saying in relation to contracts, family disputes, property, divorces, these kind of issues. Okay, so over time this concept of ADR built up, and now we have proper procedures in place for a lot of these concepts. But what are they? First one is something known as mediation. You know what is mediation? It's simply talking. It's such an informal method of dispute resolution. It's like saying, get a third party who is unrelated to the parties in dispute and ask them to solve the matter for you. Now, mediation can be done by anyone. Doesn't have to be before a judge. It can be done by family members, it can be done by close friends. In fact, if there's a dispute amongst two people in this class, I could be your mediator. There is no requirement, skill, nothing. Just that I have to be an independent person. But that also, to an extent, there's no criteria in place. Okay, it is an extremely informal method of dispute resolution. It's like saying, just try going and talking. Try to communicate with each other. Try to understand the problem and try to come to a solution. So, this process of mediation involved someone known as a mediator. An independent third party who heard both sides of the dispute and tried to get the two parties to communicate with each other. That was his only role. And if parties could come to some sort of settlement or agreement as a result, then what is the need to go to the court of law? Correct? So, mediation is one type of an informal case of ADR. The second one is known as negotiation. Now, negotiation is also like mediation only to a certain extent. Here again you will have someone known as a negotiator, but this person is required to have some skills. He should be proficient in communication, problem solving. He should be capable of understanding your problem and arriving at a solution, helping both parties to negotiate with each other. Okay, so if you see to a large extent, mediation and negotiation can be used interchangeably. The words can be used interchangeably, and both these methods are informal methods, or at least were informal methods. Now slowly the courts have started realizing the importance of mediation, and they've realized how how helpful it is. If people can simply sort their disputes through mediation, then you don't have to come before the court of law and go through all the hardships and delays and the costs and all of that. So now some high courts have passed mediation rules itself. Like they're saying, come to the high court, I'll designate a room separately known as the mediation space. You go sit there, you mediate between your problems, then come back to me and tell me that your problem is either solved or not solved. So it's slowly starting to become formal, but mostly we'll say that mediation and negotiation is informal. Why am I saying informal? There's no law regarding it. There's no rules, procedure, nothing relating to mediation and negotiation. The third one is known as conciliation. Now, conciliation, and fourth one I'll mention over here, arbitration. Okay, now these two are formal in the sense that the law governing this is itself known as the Arbitration and Conciliation Act. So we have specific rules as to how arbitration should take place, how conciliation should take place. But conciliation will have a person known as a conciliator. Okay, and through this chapter we will study about what his roles and responsibilities are. Okay, a conciliator will be required to understand the problem and provide the solution and get both of the parties to arrive at that understanding. If he can try to get them to that understanding, they'll sign off on that agreement and the conciliator's approval will be sent to the judge. And if it's approved, then great. But if the conciliation doesn't work, then it will go back for proceedings before the court. Okay, so we will be studying about conciliation separately. And finally, we have arbitration, which are done by arbitrators. I will say arbitration is the most formal method of ADR. Very stringent rules regarding arbitration, which is what we're going to be looking at right now. Fine, so these are your 4 methods of ADR. In fact, there might even be a question to you all saying what is ADR and what are the methods of conducting ADR, and these are your 4 methods. Okay. In its in its, sorry, if you have to see the number of processes and procedures for each one of them, you'll notice that arbitration has the most stringent process. Lesser for conciliation, lesser for negotiation, and almost nothing for mediation. What do I mean by this? About where it should be conducted, who should be the arbitrator, mediator, etc., how to conduct it, within how much time should it be completed. All of these are the processes that I'm talking about. Okay, so we'll be starting out with arbitration, we'll finish the whole of arbitration and then only proceed on to conciliation. And then we'll be looking at some rules of mediation that has been passed by certain high courts. Arbitration is gaining a lot of traction these days. Why exactly is arbitration getting traction? We look at now. Now, before I start off into arbitration, let me just recap a small thing, that is the provision regarding tribunals. We all know what tribunals are. They are quasi-judicial authorities. So, if you see technically, even a tribunal is a form of an ADR only, alternate dispute resolution, because you're going to a separate court for some kind of a civil matter. Now, do you remember that I told you for tribunals, the Civil Procedure Code is not applicable, and even the Evidence Act is not applicable, correct? This is so as to prevent the extremely lengthy cases, etc., and for quicker dispute resolution. But what is applicable? Your principles of natural justice. That's your audi alteram partem and rule against bias, correct? So, why, not why, but a tribunal will not be governed by the CPC and the Evidence Act, or more specifically the Bharatiya Suraksha. I'm sorry, I'm yet to get the evidence law name, but for now I'm going to call it the Evidence Act. Okay, BSA, is it? Sakshya Adhinyam. My bad. Even I need to get my name, my pronunciation around it. Okay, so BSA we'll call it. So basically the BSA. Okay. Now the same rules applying to a tribunal applies to an arbitration. Okay. So if you see, all tribunals follow a certain method of procedure. But we can say that arbitration is a special type of a tribunal because it's governed by special rules under the Arbitration and Conciliation Act. Now, if you see a tribunal, right, it will have one judicial member, one technical member. So, that is one member belonging to the judiciary, one member belonging to the executive body. They will be governed by the principles of natural justice. And certain proceedings will follow as per the provisions of the law itself. Now, arbitration also happens through a tribunal only. It is known as an arbitral tribunal, but the procedures to an arbitral tribunal are completely different. So, please understand that yes, arbitration is governed by what a tribunal is also governed by, but there are special rules attached to it. Okay. So, what exactly is this arbitration? Now, arbitration is a very special concept because it is giving a lot of power to the parties involved. I'm saying a lot of power given to the parties themselves. Okay, what do I mean by this is that, okay, first answer this question to me. When you go to the court for dispute resolution, do you get to choose your judge? No. You are designated a court that you are required to go to, and that is the jurisdiction that we've studied. Depending on movable, immovable, others, whatever it is, we've established jurisdiction and you are required to go to that court only. But say you go to that particular court, can you choose who your judge is? Can you? We can't. But in arbitration, you can choose your judge. Okay? Can you decide which court you want to go to in the sense? If you want, can you go to a foreign court to get your dispute heard? No. But in arbitration, you can go to a foreign country and ask for a foreign arbitrator. This is what I mean by the procedure and power is given completely to the parties involved. Okay? Why is this given? This is given so that if we give all of the power to the parties, then they will be happy with the decision that finally comes out. So if I get to choose my judge, I get to choose the place of my arbitration, the language in which my arbitration takes place, the procedure in which the arbitration proceedings are conducted. If I, as the party, get to choose all of these things, then finally any decision given by that court, I will be okay with. I have to be okay with. And so they are saying any decision given by an arbitral tribunal can never go on appeal. Make sense? You've been given all of the authority. You choose your judges. You're not happy with the judges, change them. Choose your place of arbitration. Choose even which law is applicable to you. If you want the Singapore Companies Act to apply to you, you can go to Singapore and be governed under that law. Okay, if you want an arbitrator of like a French national, you can have an arbitrator who's a French national. Okay, you can have everything under your control. But finally, when the decision is given by that tribunal, then you are bound by it. And you can never go on appeal. You can't go on appeal to a high court, Supreme Court, nothing. Okay, and there's one more thing. Arbitral tribunal proceedings has to get over in 1 year. 1 year. That is the maximum time given for the proceedings to complete. So it is faster, speedier, and most businesses will be, what do you say, they'd prefer if legal proceedings get over faster. And so we are seeing that arbitration is getting much more, I mean, it's becoming way more popular than it has been in the last 5 years. Okay, so this is your concept about arbitration. It is governed by a tribunal, but the procedure is governed by the parties. This is what arbitral tribunals are. And finally, they say that there is no right of appeal. Okay. Time period is a maximum of only 1 year. So these things become very attractive for alternate dispute resolution. Okay. So based on this, let's try to understand what is the process in which an arbitration proceeding will start. Fine. Now, if we look at the earlier provisions, before the Arbitration and Conciliation Act came out, we had a provision for ADR that was there in the CPC, which simply said that the judges have the power to refer parties to out of the court settlement. But that's all it said. One line sentence, and it could be interpreted in multiple ways. But what we need to understand is an arbitration can never go completely separate from the judiciary, because at the end of the day, it's still a dispute resolution. So if it's a dispute resolution, it still has to be governed by the court of law only. But then the court will send you to arbitration, get you to finish the whole proceedings, come back to court and approve of it. This is how it works. So how does an arbitration proceeding start? It starts with the submission of plaint to the court of law with the correct jurisdiction only. Okay, so just like how your civil proceedings will start. How does your civil proceedings start? With the submission of a plaint. But here there is a slight deviation. At the time of submission of plaint, you have to submit something known as an arbitration agreement. this is what actually starts the arbitration proceedings. Okay, so what exactly is an arbitration agreement? What is an agreement? Two or more parties have agreed to something. Okay. How do two or more parties come to an agreement? Written or even through actions. Okay, but here when we refer to any arbitration agreement, we will rely on a written agreement only. So what is that? What is the form of a written agreement? It can be in the form of a formal contract. Say between A and B, they could be business partners, they could be partners itself, and then they may have a separate arbitration clause. Sorry, have a separate arbitration agreement itself. If any dispute arises between us, then we will refer this to arbitration. This is one way in which an arbitration agreement could exist. The second way it could exist is a clause in a contract. It means there will be some other contract between the two parties, and say clause number 10 will say arbitration clause, that in the event of any dispute arising between the parties to this agreement, we refer it to a single arbitrator situated in Coimbatore. So it can be a clause in a bigger agreement or a bigger contract. But they are also including one more thing. They are saying any communication of emails or SMS or any kind of messages. So letters, SMS, even these can amount to an arbitration agreement. So what exactly does the party have to do? While submitting the plaint, he has to submit the arbitration agreement to the court of law. Now obviously what will the court do? He will have to summon the defendant. Okay. Why is he summoning the defendant? Is because, remember, I told you the court is still overseeing this dispute resolution. You're not going away from the court for a separate dispute mechanism. The court will summon the defendant, and the court will also ask the defendant, are you okay for arbitration proceedings? Okay, because remember, this formal contract, a clause in a contract, etc., may be agreed to between the parties. But what if it's an informal communication? That is, exchange of letters or SMS. It might not be clearly written saying, okay, if there's a dispute, I agree to arbitration. It might be a very informal mention of words. So they'll call the defendant to the court, and the defendant will have to agree, saying that yes, I'm okay with arbitration. Okay. Now, is it required for only the plaintiff to submit this arbitration agreement? The answer is no. Even the defendant can give the arbitration agreement while submitting the written statement. Okay, but in essence, it won't be a very formal thing, because if they're going to arbitration, they'll simply go and confirm saying we are okay for arbitration. Now, what happens if this arbitration agreement is not there? There is no contract, there's no clause in a contract, there's no written communication. Not everybody enters into contracts. At this point, they're saying if both the parties appear before the court of law and give their consent to the judge at that time, even then the judge can refer the parties to arbitration. Okay, so while this is the formal method, a power has been granted additional power has been granted to refer the parties to arbitration. So are we clear with this part? You still have to go to the court of law with correct jurisdiction and submit the arbitration agreement. I erase this off? Okay, now that the arbitration agreement has been granted, at this point you have to set up the arbitral tribunal. So, who exactly is the arbitral tribunal? It consists of one or more arbitrators. So, the tribunal can consist of a single arbitrator or more than one arbitrator also. Now, how exactly do you set up this tribunal? Who sets up this tribunal and how do you exactly do it? The court will not have any interference once they have referred parties to arbitration. It is the parties who will now have to appoint their arbitrators. Okay, please remember, if you go to a civil court, you don't have to choose your judge, but in arbitration you have to choose your judge. But first and foremost, you must decide how many judges you want or how many arbitrators you want. Your biggest consideration will be the fact that you have to pay your judges. You have to pay them a fee. So if you want 11 arbitrators also you can have, but you have to pay the fees for all of them. You can have 1, 3, 5, 7, 9, 11 in odd numbers. Okay. So if you are appointing the arbitrators, don't you think you have to send them a letter first asking them, will you be my arbitrator? Okay. So that is what it means to set up the arbitral tribunal. So let's just practically think about it. Let's put ourselves in the place of the parties itself. Now, please understand that both the parties must be okay with the arbitrator. Fine. Let's just break up this class into the plaintiff and the defendant. Okay. Now, you all have been given a list of say 10 people who could be potential arbitrators. Why? Because the parties will have certain preferences or criteria. They might require the arbitrator to be the ex High Court judge, or must be some judge having 10 years of experience in the district courts, or you want your judge to be a foreign national, you want a judge of say French national, or you want someone from Singapore, you want him to speak a different language. Each of you all will have different preferences. Now, both of you all have to agree on the number of arbitrators first. Okay. For the sake of this example, let's assume that we will go with the first example being you all are choosing only one arbitrator and you all are choosing 3 arbitrators. In one situation, parties have to choose one arbitrator, or in the second situation, parties will have to choose 3 arbitrators. Okay. Now, if it is one arbitrator, first of all, parties have to decide on one person. Okay. Now, let's assume that both of you all have agreed on one person. Let's say it is, let's not take examples, any one person you all have decided on. What is the next thing that you will do? You will send him a letter of request asking him to be the arbitrator in your proceedings. Okay. Now, he will respond to you, wherein he might say, yes, I will be your arbitrator, or he can even deny it. He can even say, I'm sorry, I don't have the time for arbitration proceedings, or for whatever reason, I cannot be your arbitrator. Okay. Now, what if the arbitrator has a relationship with one of the parties, whether pecuniary or any other relationship? Say this particular arbitrator has shares in your company. He is disqualified from being a judge? Technically, no. If the parties are okay with it, he can continue to be the arbitrator. But there's one condition. He has to disclose any kind of relationship that he has. The arbitrator. Okay, so the arbitrator is required to tell both the parties, see, I am holding so many shares in your company, or my relative has taken a loan from your company, or I have such a kind of relationship. And there are certain criteria which are mentioned in the law itself. That says if you fall under any of these criteria, you'll have to disclose it. Now, after disclosure, if both the parties are still okay with it, then they can proceed to hear the matter. They can proceed to be arbitrators in the tribunal. So there is no automatic disqualification over here. The condition is that he has to disclose, and if parties are okay with it, he can be the arbitrator. But obviously, if the parties are not okay with him, then they'll have to choose a different person. Fair? Now, this is in the situation of one single arbitrator. Now, come to the situation where there are three arbitrators. Okay? First of all, there's a dispute between the parties. They are already not in agreement with each other. Now, you're trying to get both the parties to arrive at three arbitrators in agreement with each other. Most of the times, that does not happen. Okay, and that is your biggest problem. That's why most people will go with a single arbitrator only. Apart from the cost, there is a problem in choosing arbitrators that are best for you. But some people might decide, again, it's the choice of the parties, they decide to go with three. Now, the thing is, only if the arbitrators confirm, the tribunal is even formed. Now, how long will parties keep on deciding which arbitrator, or one party might be okay with one person and another party may not be okay with that person, and it will keep going on for a very long time. So, where there is more than one arbitrator, if it's taking a very long time to arrive at the number of arbitrators, there are certain provisions given under the Arbitration Act. They're saying first you try to arrive at a decision. If you are unable to arrive at a decision, one party choose one arbitrator, the other party choose another arbitrator. Both the arbitrators will choose a third person, known as the principal arbitrator. But again, all of the arbitrators must be as per your specifications and requirements. They can't be, if you requested for a French national, then he must be a French national. They can't choose someone who is Italian national or Indian national. Okay? So this is one way. But even post that, if you are unable to find an arbitrator, that time again the court will step in. The court will step in and say, listen, I am going to choose an arbitrator for you, but I will choose only one arbitrator for you. So regardless of your requirement of 3, 5, 7, 9, I will choose only one person for you, and then proceedings will have to start after that. Okay? So choosing of arbitrators or appointment of arbitrators is the next most crucial step. So I'll just write this down for you. 1, a request letter should be sent. Okay? Then acceptance and disclosures, if any. Acceptance by the arbitrator and disclosure, if any. Okay. Once the acceptance is given by the arbitrator, we can say that arbitration proceedings has officially started. Fair? Once he's given his acceptance, then we can say arbitration proceedings have started. Now, the parties also have to decide where they're having their arbitration. Is it in India? Is it outside India? That's also their choice. But all the costs of arbitration will be borne by the parties only. So they will have to find a residence for the arbitrators, pay for it, take care of their living expenses there, pay for the fees of the arbitrator. That is their cost. Okay. Now, I'll just mention it very simply over here. The arbitrators, the place, the language, the procedure, the law applicable, everything has to be decided by the parties. Okay. What do I number of arbitrators? Fine. Place of arbitration? Fine. Language, procedure. What do I mean by law? Which they can even decide which law is applicable to them. If they want Indian company law to apply to them, they can have it arbitrated in India. If they want Singapore company law to apply to them, they can have it arbitrated in Singapore. There are some conditions and clauses to that, we will study that later, but that is also the choice of the parties. So, are we clear on this part? Yeah.
How can a company register company in India and go to Singapore?
They can do that. That's the thing of arbitration. So, one more thing about arbitration is that it is an international agreement. All the countries have gone to Vienna as well as New York, signed a treaty, and in that treaty they had a model law of arbitration, which we have implemented as law in our country. So, all the countries that were party to that treaty will have similar laws of arbitration. Okay, so Singapore falls into one of them, but yes, Singapore company law will be slightly different from Indian company law, and arbitration law itself gives that power to parties. If you wish, you can go there and get it arbitrated over there. That is the benefit. Again, there are conditions which we will refer to later. Some things cannot be against the fundamental policy of our own country. So, in that case, it will not be allowed, but again, we will come to that provision later. Okay. So, quickly let's cover this. You go to the court of law with the correct jurisdiction. You submit the plaint and the arbitration agreement at that stage. Can the defendant also submit arbitration agreement? Yes, but he must submit it along with his written statement. They cannot go for arbitration once the plaint and the written statement have been submitted. They cannot go for arbitration after that. Okay. Now, once the court has referred them to arbitration, within 30 days they have to appoint the arbitrator. 30 days. So, there is a period of 30 days over here wherein tribunal will have to be appointed. Sometimes it exceeds that point, and that's when alternate methods of choosing arbitrator comes in. Okay. But please remember, this is a dispute, and in civil law we studied that sometimes there is a need for immediate relief, immediate remedy. Now, at that point, who has to give the immediate remedy? Who can give the immediate remedy? Correct. The court will only have to give. So, they are saying till the time the tribunal gets appointed, the court will give you immediate relief. But once the tribunal is appointed, then the tribunal only can give you that immediate relief, and we call that as interim relief. Okay. So, during this 30-day period, court will give interim relief. After the tribunal is appointed, then the tribunal will only give the interim relief. Okay. Now, let's assume that the tribunal has been appointed. Okay. At this point, start thinking of it just like how you look at civil proceedings. What did we say happens in civil proceedings? You will have to submit evidence, discovery of documents, production of documents. Everything happens the same way. But remember one crucial point I said in civil law, the court itself has the power to determine its own jurisdiction. Correct? Even though you've gone to the court and everything has started, the court will first check whether it has the jurisdiction to hear the matter. And the same way, even a tribunal has the power to determine its own jurisdiction. So, this we will go into a little bit of detail. Can everything be arbitrated? And when I say everything, I mean civil as well as criminal? No. So, what can be arbitrated? Civil, commercial transactions. Okay. Criminal offences can never come under arbitration, because one, they are wrongs against the society. They are not against a single individual. So, criminal wrongs can never come under arbitration. Can fundamental rights be arbitrated? Definitely not, because that power vests solely with High Court and Supreme Court. You will notice that even under civil laws, there are some things which cannot be arbitrated. Okay, there are mostly, if you see, commercial transactions, contracts, family disputes, anything which is a right in personam, and some rights in rem can be arbitrated by the tribunal. Okay, so let's say for example it is a breach of contract, you can definitely go for arbitration. It is a divorce proceedings, you won't go for arbitration, you will end up going for a mediation or conciliation. Okay, there are certain subject matters which can be arbitrated upon. What if you go for arbitration just for them to find out that this cannot even be arbitrated upon? They'll determine that when they're determining jurisdiction. Okay, and after that they will submit all evidence, affidavits or any kind of statements. It can even include any expert opinions. All of this will be given at this stage. Like I said, think of it like as if it's a proper judicial proceedings at this stage. Fine. And just like how a court will give a judgment or a decree, after hearing the entire proceedings, the arbitrators will give something known as an award. An award is equivalent to a decree. That's what the definition says. It is to be treated just like a decree under the Civil Procedure Code. Now, technically, against a decree, you can go on appeal. Can you go on appeal against a decree? No. Yes. You can't go on appeal against an order. Okay. However, an award, there is no right of appeal. Why is there no right of appeal? Because we gave all the powers to the parties to determine everything. Right? So, finally, when an award is given, that is the end of the arbitration proceedings. Generally, when we look at certain timelines, okay, the entire proceeding should be completed within 1 year from the date in which the arbitrator accepted to be the arbitrator. Because only when he accepts, the tribunal is even formed, and the tribunal will dissolve after 1 year. Okay, so within that 1 year period, they have to give the award. But then the Act provides for a fast track procedure. It says that you can get the award passed within 6 months' time if you pay a higher fee. If you pay a higher fee to the arbitrators, and if you do away with all oral hearings, then you can request for this to become a fast track procedure. So, just by submission of documentary evidence and within a period of 6 months' time, the award will be passed. Okay. This is only the basic of your arbitration. Now, from here we have multiple ifs and buts and exceptions and etc. that we will be studying about. I'll just finish off with one last topic before we wind up for today. What happens if during the entire proceedings you wish to challenge the arbitrator? Or more specifically, I'll give you an example that you have appointed the arbitrator, the arbitration proceedings have started. 6 months into the arbitration, it's found out that one of the arbitrators has a certain relationship with one of the parties. It can be pecuniary, it can be some form of relationship. And let's say the party B against the tribunal. Okay. Now, the concept of this whole arbitration is that you are going away from the court to hear your dispute. Now, what happens if one of the parties are not happy with one of the judges in the tribunal or one of the arbitrators in the tribunal? The question is, if he has the power to appoint the arbitrator, does he also have the power to challenge the arbitrator? When I say challenge, take a accusation to him and say that I am not happy with you being my arbitrator, please leave, I'll appoint someone else. The answer is yes. If they have the power to appoint, they also have the power to challenge the arbitrator. But there's one small problem over here. Once the arbitral tribunal is constituted, you can't go to anyone else for any problem. If you wish to challenge your arbitrator, you have to approach the tribunal itself and say that I'm unhappy with one of the judges. So let's present the situation this way. Party A, Party B, I'm your arbitrator. I'm a sole arbitrator. Party B comes to the realization that I could have some pecuniary relationship with Party A that was not disclosed prior. Only if it was disclosed prior and they were okay with it, it's all fine. But it was not disclosed over here. So at this point, what does Party B do? You will have to raise the issue before someone else. Now, should you go to a court of law or should you approach me itself? Are you understanding? You wish to challenge me, but can you approach the judge itself and say, I'm not happy with you? Or do you wish to go to a court of law? The court that originally referred you to arbitration. Isn't it better to go to the court of law? But they're saying that you can't go to the court, you have to go before the tribunal itself. And when you come and challenge me as the arbitrator, I can reject your application too. I can say that, sorry, this is not enough evidence, I shall continue to be the arbitrator. Why is this happening? Because technically there's a bias over here. I cannot be a judge in my own case. But in this arbitration, they're saying you have to be the judge in your own case, especially if one of the parties is challenging you. Okay? Why are we doing this is because if every party keeps challenging every arbitrator, the arbitration proceedings will never come to an end. And so there are certain remedies for it later on. They're saying that if you all made an application to me, challenging me, and I rejected your application, then after the award has been given, you all can go to the court of law and get the arbitral award set aside. Let me repeat it again. If one of the parties is challenging the arbitrator, they have to approach the tribunal itself. The tribunal can either accept their challenge or reject the challenge. If the arbitrator accepts the challenge, they will resign and then a new arbitrator will be appointed. But if the arbitrator rejects the challenge, they will continue hearing the arbitration proceedings. Okay? But this party, Party B, has a remedy. Remember, we cannot go and appeal against an award. But this party will have the right to set aside this arbitration award after the award is given. So would you rather finish the entire proceedings and then get it set aside, or the arbitrator itself resigns? But what if it is a valid claim, the arbitrator will resign himself. But if it's an invalid claim, then they can continue with the proceedings. This is purely done so that arbitration proceedings come to an end within the respective timelines. So while this is the process for arbitration, even arbitrators can be challenged. Arbitrators can be changed midway. Okay, and if necessary, even the 1 year period can be extended. Most of the times, you cannot go back to the court of law for any kind of remedy. Because I'll tell you what parties will do. If they realize that the arbitration is going against them, please remember they don't have the right of appeal. They are bound by the decision given by the arbitration. So at that point, rather than accepting the award, they will simply go and challenge the arbitrator. They might simply go and claim that the entire proceedings happened without my consent. So to prevent these kind of unwanted activities, they say that let the proceedings come to an end. If your allegation was actually true, then afterwards you'll have a remedy. But if your allegation was not true, then I will dismiss your actions. Okay. So we'll stop over here with regards to arbitration. Have you all understood the basic concepts?